Hey everyone. So on this channel, you've seen every type of case imaginable. Some are sad, many make you shake your head and wonder. Some are infuriating, while others make you laugh. Then the rare case comes along that just hurts your heart. This is one of those cases.
Police say a little boy who was wounded in a shooting this morning has died.
There are currently 4 leading theories on the purpose of criminal punishment: deterrence, protection, retribution, and reform. All of these things combine together to hopefully make our society a better place. But when you come across a situation like this, you can tell how difficult it is for the judge to try and apply each of these areas into developing a sentence. There is no punishment that this judge can give this defendant that will come anywhere close to touching the torture of the memories, the regret, the pain, the anger, that internal battle that this young man will have for the remainder of his life.
Early in the investigation, police said it appeared the shooting was a tragic accident and a somber reminder of the importance of gun safety. Officers responded at around 11 a.m., arrived to find family members had already transported the child to Hughes Spalding Hospital with a gunshot wound to the head.
The information we're getting at this point is that that injury is most likely going to be a self-inflicted from a firearm that child located in the home.
Following this tragic accident, Aiden's father, Dezal Thomas, and mother, Ashley Kelly, were arrested and charged with murder in the second degree, involuntary manslaughter, cruelty to children in the second degree, and reckless conduct for allowing the firearm to be reachable by the child. The charges against the mother were eventually dropped, which is discussed briefly at the start of one of the hearings. This case is over 4 years old. One of the primary reasons for the delay, outside of the standard Fulton County delays, is the defense attorney is involved in the YSL trial and must coordinate his schedule. It's very interesting to see the amount of time this drug on through no fault of the defendants. This case is also kind of interesting due to Georgia having some of the weakest gun laws in the country. There are laws that will charge parents for providing them to minors in certain circumstances, like if they know they will be used in the commission of a crime. However, Georgia does not have any safe storage laws or required locking devices or anything. They also legalized permitless carry. In the wake of this tragic accident, legislation was proposed, but it did not pass to create safe storage laws.
Dezal Thomas, and I think we've got Mr. Thomas on. Yeah, Mr. Thomas, is that you?
Judge, he is on, and we did file a waiver. It just hasn't shown up on the docket sheet yet.
Yeah, Ms. Nelson told me that you've waived, so we can make this real quick. There is Mr. Shapiro, is this your case?
It is, Judge.
All right. There's a co-defendant listed in CP status. Is that someone that is going to be joining Mr. Thomas, or is that any sense of that, or is that something strange on my calendar?
No, Judge, I am also showing that that's for Ms. Kelly. I believe I do not have an update on the status of that, but I can reach out to our case intake unit and see if I can find out.
Okay, there was a decline to prosecute actually filed about 2 weeks ago. So Mr. Thomas stands alone. He's represented by Mr. Harvey. Mr. Harvey filed the waiver. So we'll get a scheduling order in place. Mr. Harvey, Mr. Shapiro will get you discovery. I don't know what, let's look up Mr. Thomas's bond, what kind of conditions he has, and if any of them are kind of out of date since his bond is almost 3 years old.
No, the only thing that we need to change, Judge, on the bond, and it's a commercial bond, is the address. And I don't know whether I want to announce the address at this particular point, but that can be changed through the clerk's office as well.
Okay, so the address that is in the system, not on the bond, but in the system with a West Manor Lane, you think that's an old address?
Yes, sir, I know it is.
You know it is. Great. Well, then if Mr. Harvey, you would work with Ms. Nelson to get a change of address filed. That way Mr. Thomas will get notification as well as you. Double coverage is always good. So if you'll just share that, and we'll get this case moving forward. Any sense about discovery, Mr. Shapiro?
We can get it served to Mr. Harvey probably by close of business today, Your Honor.
Great. Okay. Then I'll get that scheduling order out and we can move the case along. Mr. Thomas, do you have any questions? Not about the facts of your case, that's for you and Mr. Harvey, but just sort of procedurally where we are?
Mr. Harvey has a colorful backstory. He has been practicing law in Fulton County since 1977. There's a great article about him on this website. Link is in the description. But he is also one of the remaining attorneys in the YSL case for one of the defendants that's still on trial. I'm sure most of you are aware they started with like 20, almost 30 defendants, and a lot of them took plea deals, and they're down to just a handful. And he is still active in the trial. So I left some of the scheduling in because it's kind of interesting. They have to try and weave this defendant's case in between the openings that Mr. Harvey has in the YSL case. And because of that, it's taken many years to prosecute.
No, I don't have any questions.
Okay, we'll be in touch with Mr. Harvey. He'll get discovery soon. He'll want to talk to you about the case. And he will also take care of getting your address changed so that we're sending court notices to the right place, okay?
Okay, thank you, Your Honor.
Mr. Harvey, anything else?
No, sir. Thank you. Can we?
All right. Yep, you both may be excused. Thanks for your time.
All right. Thank you. Bye-bye.
Okay, thank you.
Your Honor, that's my only matter.
We don't need to take this part down. So Mr. Thomas, we were trying to squeeze in a motion to suppress for today, but didn't consult with Mr. Harvey's calendar, and he got pounced on by a whole bunch of other litigation managers around the state when they learned that there was a break in the action with YSL. You've already strode up to the podium. Anything you want to say first, Mr. Jordan?
No, Your Honor, just the same thing that I communicated in the email, that we were finally able to get the phone dumps over to Mr. Harvey via Miss Jamie Roberts, who is with his office. And a new offer has been extended in the case as well.
Okay. Mr. Harvey, good afternoon. Just like that, he went mute and turned the video off. He managed to get the video back on. That's a start. Mr. Harvey, do you know which button to press to unmute? Excellent. Someone pressed it for you. Can you hear us?
I can't hear anything.
Pardon me?
I cannot hear you if you're speaking to me.
Well, you managed to respond. Oh, okay.
I think you have to unmute.
Ms. Rivers, can you hear us?
Yes, I can.
Okay.
The speaker might be muted.
Yeah.
Or his speaker might not have any volume on it.
He keeps
It's you. It's you.
It's not.
It's you.
Send him a chat to see if he.
You gotta unmute me.
One
He
else
has to unmute me.
can hear you. Is that backwards?
No, it's perfect.
That's perfect.
But yeah, well.
Your speaker.
I'm going to write that next. Is your. I have to make him look up.
Oh, he's writing.
Yeah, no way to do it.
Yeah.
Ah, there he goes.
How do you get that off? They get that off there.
I can't hear you. You have to unmute you. You are unmuted. This is the way he gets out of court.
I'm unmuted.
Can you hear us?
He has to.
Hey, Bruce. Is your speaker volume on? Look at the little icon down at the bottom right of your screen and see if there's an X on your speaker.
Yeah.
So your speaker might be off because we can hear you and everybody else on the Zoom can hear Judge McBurney. Sorry, Your Honor.
That's all right.
Thought this might be quicker than the notes.
No, this is great.
Okay, no.
Can you hear us?
Yep.
So if you hang up, can you still hear us?
Yes. So I think
See, I have a future in IT.
You do, and Mr. Harvey does not.
some troll came in and changed the settings on my on my computer. I think it was some guy named Kenny Shepard or something.
Yeah, I think it was someone from the DA's office crack surveillance team wanting to know what's going on, the defense strategy.
Yeah. Okay. So not too crack. Okay.
So what I wanted to sort out from you, Mr. Harvey, is your best sense of when we might. The suppression hearing shouldn't take too long, but we need a hour of your time, hour and a half. Did Judge Glanville set a routine of no Fridays in court, and so we just need to get in line on a Friday, or what's the best way to do this?
No, he has not yet. What he has said is once we get sort of structured next year and have a regular routine where it's not broken up by the holidays, he would consider giving us Fridays dark.
Okay.
I know that he is going to give us the week of Martin Luther King, that entire week off. Now, I don't know what date that is. I'm sorry. But well,
conveniently, that's the judges' conference. So he wisely picked that because he's got to go to the judges' conference.
Okay, I see. Well, can we just waive your presence?
Yeah, go for it.
Hash it out in the MMA ring or something like that.
Yep. But you'll bring Monis and he'll kill everyone.
That's exactly right. That is exactly my tag team partner.
Exactly. And you very quickly tag. We may be able to do it Tuesday morning of that week. So I'll get with Ms. Nelson and then she can check with you and Mr. Jordan. But that may be our next available date until you get that cadence with Judge Glanville that says we're taking Mondays or Fridays or whatever it is he decides to take off.
That's great. And Mr. Jordan needs to decide what we have a motion to suppress, like the phone dump, for example. And as far as I know, the state has not made a final decision as to whether they were going to use that at all. So we may be able to avoid at least a hearing on that part of it by the state saying, yeah, we've had some time to think about it. We're either going to use it or not going to use it. So that may obviate some of that. Is that correct?
That is correct, Your Honor. I've gone through the phone dump. I don't have a final answer for Mr. Harvey in the court today, but I don't see anything particularly useful that Mr. Thomas or Ms. Kelly had in their phones, but I'll make sure to have a definite answer long before the 15th.
Was there another part to the motion to suppress? I thought it was just the phone stuff.
From my understanding, Mr. Harvey, and correct me if I'm wrong, it was also the search of the home, which yielded the firearm and pictures.
Okay.
And it was also the phone dump were the two major items of the motion.
Okay, so that's why Mr. Harvey was saying this would shorten the hearing, but it wouldn't eliminate the hearing. And I'm all for a focus if we can get it.
Yes.
And since we can't do the hearing today, that gives you more time, Mr. Jordan, to assess what you're going to do with the phone. You can make that official at the hearing. Obviously, the sooner you can let Mr. Harvey know he doesn't need to prepare for the phone part of it if you're not going to use it.
Yes, Your Honor.
And if you ever change your mind, then we just need to litigate that piece. But it'd be good if you can reach a state of semi-certainty before we set this down again for the hearing.
Yes, Your Honor.
Okay.
That's a Daubert standard, by the way.
Yeah, semi-certainty. Ms. Nelson is saying that Tuesday morning would work. Is that currently open for you, Mr. Harvey? I'll get specific with numbers. That is the 16th.
Let me look. In my inability to get two screens at one time,
Yeah, now it's going to go mute on us.
or something. No, I'm going on my phone for that. Let's see. I don't even know how to get to January on my phone. Let's see. The 15th is a Monday, correct?
The 15th is a Monday, so we're talking about the 16th.
I've got a Zoom status hearing in federal court, Judge Boulay at 10 o'clock. That should not take very long. Other than that, that looks like a good day, Judge.
Okay, so would you be able to be here by 10:30? Would we say 11?
How about 11?
11, okay. Why don't we set that down? Ms. Nelson will publish a calendar, but you write it in some space that protects that. And we'll say 11 on the 16th. Now, if I'm remembering correctly, Mr. Thomas lives far away. He's on the call now. It looks like he's in a car, but he's not local. Is that correct?
You got to unmute, Denzal. All right.
I'm local.
Oh, he's local. Good. So he could be here for the suppression hearing.
Yes.
Excellent. That's my preference. We just had a couple of hearings this morning where someone was in Arkansas, someone was in New York, and it was a little problematic that they weren't here, but what we were doing made that work out. So great. So Mr. Thomas will be here in court with you 11 a.m. on Tuesday, January 16th. We'll get a calendar published quickly so we can block that off. Anything else, Mr. Jordan?
Nothing further from the state, Your Honor.
If you could try before that date to sort out using phones, not using phones, and let Mr. Harvey and Ms. Nelson know that, just copy me as well. Then we'll know, hey, it's just about the search of the house versus phones also.
Yes, Your Honor.
Okay, sounds good. Mr. Harvey, anything else in connection with Mr. Thomas's case?
Thank you. Thank you for allowing us, Mr. Thomas, to come on by Zoom. I had a wonderful time up in Cartersville this morning.
Excellent. Well, as long as you're happy. Mr. Jordan?
Thank you.
Yeah. Anything else, Mr. Jordan?
No, Your Honor.
All right, we've covered the Thomas matter. We'll see you all on the 16th, 1/16 at 11 a.m. Thank you.
Thank you.
All right. Mr. Harvey, if you could unmute, let's get an update from you as to what the plan is for the rest of this morning.
Judge, I think I had a brief opportunity, and thank you for that, to talk with Mr. Thomas about the offer that's now on the table. I think that we can affirmatively plan that offer would be accepted, but I just need a little bit more time to talk to Mr. Thomas. Talking to him in a chat or a phone call while we're here in court, it's just not the same as having the opportunity to meet with him and to go over everything. But I anticipate that offer will be accepted. So however you want to proceed, I don't see any reason to proceed forward with the motion hearing at this particular time. There are a number of motions. Some of the motions are moot because the state has indicated to me that they will not be using anything gathered from some of the seizures. So that's my suggestion. I guess, well, can we put it on another final plea calendar?
Yes, I think that makes the most sense, with the caveat being your peculiar schedule. You're either in 1C or the Virgin Islands, and I don't want to defer this case for another bunch of weeks or months. We actually have on the call the mother of the deceased in this case, and I'm sure she's anxious for this to move forward as well. So I don't know. Hold on one second. You can mute that. Mr. Harvey, I don't know how much notice you get from Judge Glanville as to when there will be a down day. We rarely hear from him. And so we're not able to, we're sort of reacting on the spot that, oh, tomorrow so-and-so will be free. I would very much like to get a date certain that would work for you. I'm pretty confident I can grab Mr. Jordan when we can get you on a calendar. Do you have any insight as to when there'll be another, and it doesn't need to be a whole day. If you know it's a half day in 1C, then we'll get you in for the afternoon. And it's not like a plea hearing is all that long anyway.
Well, I think we'll have a number of witnesses, but be that as it may, the answer to that is, I don't know. For example, Judge Glanville had told us for weeks and weeks that we were going to be off yesterday, today, and tomorrow. And then we came in and we finished a session on Tuesday, and he said, okay, be here tomorrow. So it's a little bit mercurial with regard to days, even days that he has said are going to be administrative days. My suggestion is this: I don't know whether you have a regular final plea calendar, but if I'm downstairs and I can get someone to sit in, I can come upstairs and we can resolve this.
Okay. Why don't we do that? I'll get with Ms. Nelson. And is there a day of the week, as you understand the flow insofar as there is a flow with that trial, that is more likely that either one, you won't be in session, or two, if you are in session, you being out of there for an hour, however long our hearing would be, is less disruptive to your client?
Judge, no. There are some Friday mornings where Judge Glanville, I believe, does Veterans Court, and we don't appear until like 1 o'clock on a Friday. But that's not every Friday.
Okay.
And I don't know when that is going to occur. I generally have people that can cover for me. So if you just set it on your regular final plea calendar, I will try to make arrangements to have somebody cover downstairs, and I can come up and join you. And if that's not going to happen, although I think that's a remote possibility, then of course we'll let you know.
Okay. How much time should we bake in for this? You mentioned calling witnesses. So it wouldn't be a 20-minute affair. Is this we need all morning, or what are you envisioning?
Well, this event happened back in 2020. It was not indicted till 2022. And in the meantime, Mr. Thomas has been consistently employed. I have a number of folks from his current employment, from his past employment. For example, he worked at UPS for 5 years. So I don't think it'll be longer than an hour and 15 minutes. But you know me.
I do, so we'll bake in 2 hours.
Okay.
All right. Let me check one thing. There was a co-defendant at one point.
Yes,
How does that work?
that was the victim's mother, Ms. Kelly, who's on the call right now currently. That was declined, I believe, June 3rd of last year.
Okay. Okay. So Mr. Thomas, we're gonna get another date. You will need to be here in person for that date. Mr. Harvey will be here in person for that date. And it sounds like, although no one is ironclad committed to it, it sounds like what we'll do when I see you next is go forward with a plea. The state will, you actually just heard part of a plea. They'll do what they do. Mr. Harvey will be presenting some things on your behalf. And then I'll decide if, one, I'm going to accept the plea, and then if it's a joint recommendation, if I'm going to accept the joint recommendation. You still have what are called your final plea rights. So if the sentence I impose on that later date is something more severe than what Mr. Harvey asked for, you can always back out of it, withdraw your plea, and then we'll move forward with things. But it sounds like a lot of thought has been put into this by the prosecution and by Mr. Harvey, and I tend to be appropriately influenced by that level of preparation and investigation. So we'll see. Mr. Harvey's going to very understandably wants to meet with you face to face to talk more about this, because a plea is a significant step forward in the case. He'll spend time with you. We'll get a new date, and I will see you then. Do you have any questions about any of that?
No question, Your Honor.
Okay. Ms. Kelly, do you have any questions about what we just discussed?
No.
Okay. How will she learn about the date? Just because victim advocate will contact her?
Yes, Your Honor. We spoke with her yesterday. We'll make sure to contact her when the date is established.
Great. And so, Ms. Kelly, you will have a right to be present as well and to be heard potentially if you want to be here. It is entirely up to you, but someone from the DA's office will be letting you know the date and time of this next hearing. Okay?
Okay.
All right. Thank you. Mr. Harvey, anything else?
No, sir. Thank you for allowing me to appear by Zoom. I didn't want to give everybody a cold or whatever.
Yeah, you sound like you got some kind of ick. So thank you for keeping it in your funky loft area, and we're gonna be safe here. Okay.
Yes, sir. Thank you, Jim.
Take care.
All right. Bye-bye. I'll talk to you, Julian.
Yes, sir.
And he'll talk to you too, Mr. Thomas. All right.
Yes.
Where are you working now?
UNFI.
Say that again.
UNFI.
What is that?
Like an abbreviation. United Whole Food.
Okay. What do you do?
Order select.
Got it. So it's a warehouse thing?
Mm-hmm.
All right. Well, you are free to go for now.
Okay. Thank you, Your Honor.
Take care.
I feel like it's worth discussing the type of weapon involved. We don't know the age of it, so it's hard to know if this information is even relevant or not, but the event took place in 2020. Back in 2013, Springfield issued a recall of the XDS subcompact, citing two flaws. First, the slide could release during loading, causing an unintentional discharge. And second, the trigger could be pulled once, causing a double fire. Neither of these flaws would have changed the circumstances of this case. However, there are numerous reports online of other circumstances of unintentional firings without trigger pulls. But there is no confirmation of any of these reports by law enforcement or the manufacturer, so weigh that information as you will. Further, there are three safeties on this piece. The first is the trigger, which is built in. You must pull the two levers back at the same time. The second is the grip safety, which needs to be fully depressed and firmly held in place. The third is the striker block safety. There is an internal striker block designed to prevent discharge until the grip safety is firmly depressed and the trigger safety is pulled. Sounds like no big deal, but I will tell you from someone with smaller hands, these things are made for men whose hands are much bigger. Until you figure things out and exactly how to hold it, it's not the easiest thing to do. So if you take into account the fact that this was a 3-year-old toddler who had to engage both safeties at the same time while aiming at himself, plus holding up 2.5 pounds or so, which would have been the weight if the mag was full, it's not nothing for a little guy who probably only weighs 20 pounds himself. I'm just saying a lot of things had to happen for this tragic event to occur.
Mr. Jordan, before we get started, there's some folks on the Zoom, it just says iPhone or some other names. That's fine that they're on. Do you have folks that you expect to be speaking in the Thomas matter?
No one from the States, and Your Honor, I know that Ms. Gallagher is on here for Ms. Rawls's plea.
Okay.
But no one from the state that I'm aware of is going to speak in this case. And Mr. Harvey and Mr. Thomas may anticipate some individuals speaking on here.
Well, that's where I was going next. Do you have anyone you think has dialed into the Zoom?
No.
I just don't want to ignore someone. If you're going to have, if there's someone you want to have
No.
share.
I have Ms. Kelly here, who is the mother of Adan, the young man, the 3-year-old.
Okay. All right. Well, let's get started. This is 23 SC 187430, State versus Denzal Thomas. Mr. Thomas is here in court with his lawyer, Mr. Harvey. Mr. Jordan is the prosecutor on the case and is standing up at the witness stand so that he can be in a position where he's looking at you, Mr. Thomas. He's gonna be asking you a whole bunch of questions concerning your rights as a criminal defendant. In a moment, he's going to put you under oath. Once you're under oath, it's important that you answer his questions truthfully and completely. If you have any questions of your own, Mr. Thomas, make sure we pause. If you need to speak privately with Mr. Harvey, we can do that. If it's a question for me, I'll field it, but I need to be comfortable that you're understanding what we're talking about, okay? All right, you ready to go forward?
Mm-hmm.
Okay, when you answer, you need to make sure you answer out loud, not but a yes or a no.
Yes.
You sure can. There is a garbage can. You can swallow it, or you can find a garbage can, or give it to Mr. Harvey to put in his pocket. Excellent. All right. When you are ready, Mr. Jordan.
Thank you, Your Honor. Mr. Thomas, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Denzal Marcus Thomas.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 27 and I graduated high school. I attended college, but I didn't finish.
Where'd you go to high school?
Benjamin E. Mays.
Do you understand, Mr. Thomas, even though you're not entering a plea to all of these counts, that you have been charged with murder in the second degree as count 1, involuntary manslaughter as count 2, cruelty to children in the second degree as count 3, and count 4 being reckless conduct, which is a misdemeanor?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Harvey, are you satisfied that your client has a full understanding of this proceeding?
Yes, I am.
Also, Mr. Harvey, do you waive formal reading of this indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Thomas's name?
For purposes of this plea, yes.
Mr. Thomas, do you recall originally having been arrested on these charges?
Yes.
It was a while ago, but at some point you were arrested in connection with this?
Yes.
Okay.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Harvey, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. Thomas, do you understand that you're entering a guilty plea to counts 2, 3, and 4 in this indictment, which are involuntary manslaughter, cruelty to children in the second degree, and reckless conduct?
Yes, sir.
Do you understand the minimum and maximum sentence for each charge that's on the indictment that you will be entering a plea to.
Would you spread that on the record for him, please?
Yes. For count 2, the minimum is 1 year and the maximum is 10 years. For count 3, cruelty to children in the second degree, the minimum is also 1 year and the maximum is 10 years. And for reckless conduct being a misdemeanor, the minimum is 1 day and the maximum is 12 months. Do you understand the minimum and maximum sentences for those charges, Mr. Thomas?
Yes, sir.
Do you understand that this is a non-negotiated plea with a cap, which means that the state will recommend a sentence to the court and your attorney will also have the opportunity to ask for a recommendation to the court?
Yes, sir.
Mr. Thomas, do you understand that the state is recommending to count 2 that the sentence be 10 years to serve 2 years, the balance being probated, the special conditions of probation being that the defendant forfeit all firearms, or if any are currently owned, a Fourth Amendment waiver, and that he have no drugs or alcohol while on probation. Your Honor, given that the factual basis here does not involve any alcohol or drugs, I will remove that request.
Okay.
And do you understand, Mr. Thomas, that the state's recommendation towards count 3 is 10 years to serve 2 to run concurrent with count 2, and for count 4, I believe count 4 will merge as a matter of law, Your Honor.
The reckless conduct merges into the involuntary manslaughter?
Yes, Your Honor.
Okay.
Was that the most recent recommendation that was communicated to you, Mr. Thomas?
Yes, sir.
Do you understand that the court does not have to accept the state's recommendation or your attorney's recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on these charges and run them consecutively or one after the other?
Yes, sir.
And Your Honor, I believe that Mr. Thomas still has his final plea rights. Would you allow Mr. Thomas to be able to withdraw the plea after today?
I don't know that he does. I don't want to argue about it. Let's just work through this and he'll have an opportunity to talk with Mr. Harvey after I pronounce sentence and we'll figure out what we're going to do.
Yes, Your Honor. Mr. Thomas, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Mr. Thomas, is it your decision My apologies. Mr. Thomas, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
We're going to be asking the court for first offender, but the answer to that is yes.
First offender is different from offered. It's not an offered, you know this, but your client, this is not a nolo or an offered plea. He's pleading guilty to the reckless conduct that resulted in the involuntary manslaughter charge. We'll work through first offender, but I just want to make sure I'm following the way this is structured. Is a guilty plea, there may be a disagreement between the parties about first offender. We'll work through that. Is that correct?
Yes.
Okay. And Your Honor, the state has no objection to the defendant entering this plea under first offender. Would you like the state to go through the first offender?
I'll do that with him.
Thank you very much. Mr. Thomas, how do you plead to the charges of involuntary manslaughter, cruelty to children in the second degree, and reckless conduct in indictment number 23 SC 187430?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that for the felony charges that you're entering a plea to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea? And for the misdemeanor that you're entering a plea to, you have only 12 months from today to file that same petition.
Yes, sir.
And Your Honor, for a factual basis, on July 28th of 2020, the Atlanta Police Department responded to 3310 West Manor Lane, which is in Atlanta, Georgia, within the confines of Fulton County. Police were originally dispatched out to that location, Your Honor, after the nephew of the defendant called 911 after hearing a pop and then seeing his uncle, the defendant, run out with the decedent child, Aiden Kelly, who was 3 years old at the time of the incident. The child was in Mr. Thomas's arms and was bleeding profusely. When the 911 caller called, it was not clear how the child was shot. The 911 caller simply stated that a child had been shot in the head. Based upon that, police officers did enter the location that was previously mentioned. Inside of the location, they did see a large amount of blood, and I apologize for the graphicness of this, but brain matter that was located on the curtains that were near an air mattress. They did not find a weapon at that time. The police officers were then informed that the child, whom Mr. Thomas and the child's mother, Ms. Kelly, who is present in the court today, had taken the child to the hospital. The child was declared deceased not long after reaching the hospital. I believe they may have tried to transport the child to another hospital.
Hugh Spalding.
To Hugh Spalding, but the child.
That was the first destination, or the first destination was the closest medical center, and from there they brought Aiden to Hugh Spalding.
Yes.
Okay.
Your Honor, the child was declared deceased. It goes without saying that the cause of death was a gunshot wound to the head. The autopsy did confirm that the gunshot wound was sustained at a very close range to indicate that the child had unfortunately shot himself. Mr. Thomas and Ms. Kelly were interviewed. Both of them gave very similar renditions in which all of the occupants of the apartment, which I believe were Mr. Thomas, Ms. Kelly, and 2 children, they all went to sleep. There may have been a portion in which the decedent child may have asked for candy prior to going to sleep. Mr. Thomas did admit that his handgun was unsecured. It was actually under the air mattress and covered up by a pink bonnet that I believe that may have belonged to Miss Kelly. He stated that when he woke up, He just saw that Miss Kelly was screaming or heard Miss Kelly screaming and saw that the child had been mortally wounded. Mr. Thomas was extremely cooperative in the investigation. When he spoke with police officers, he did voluntarily give a buccal swab. He gave up his fingerprints. He also signed a consent form for his cell phone. The state reviewed the cell phone and there was no relevant information regarding this case. Your Honor, Ms. Kelly was also originally charged with the same offenses that Mr. Thomas was charged with. That was declined by the state before it was presented to the grand jury.
Do you know why? I know your involvement comes after indictment and it's assigned to a courtroom with which you're associated. But why would Mr. Thomas be pursued criminally, but not Ms. Kelly? Just because of whose gun it was?
Your Honor, I believe that it was sufficiently clear that from the onset that Mr. Thomas was very clear with police officers that it was his weapon, that it was his decision to put the weapon under the air mattress.
It was his recklessness, not Ms. Kelly's recklessness.
Correct, Your Honor, in this instance. Your Honor, the state believes that the recommendation that the state is presenting is appropriate in this situation. This is not a crime of any viciousness by Mr. Thomas. This is an unfortunate decision that was made or an unfortunate instance of negligence that was life-changing and life-ending at the same time. That I'm sure that Mr. Thomas and Ms. Kelly live with this horrible event every single day. But we do believe that there is criminal responsibility for the negligence of leaving the gun under the air mattress for the 3-year-old child to be able to reach the gun and unfortunately end his life while playing with the gun. So, Your Honor, that is the state's presentation here.
Okay. There's someone on the Zoom call who is identified as Nanty, who says this person wants to say something. That's no one that your victim witness advocate has received word from or anything?
No one from our side.
Okay.
I know we contacted Ms. Kelly, but I don't believe that the state.
But she's here, so we can hear from her if she wants to add something to this. I just want to make sure we're checking all the boxes in terms of victims' families' rights, and then, of course, Mr. Thomas's family. So we will move on. I'm going to turn now to Ms. Jackson from Pretrial Services. Ma'am, good morning. Could you let me know what criminal history information you have on Mr. Thomas?
He has 2 cycles. The last arrest was April the 11th, 2015, with the City of Atlanta Police Department for possession of marijuana less than an ounce. There was no disposition for that arrest, and there are no convictions listed in the GCIC Yonner.
Thank you. Mr. Harvey.
Thank you, Judge. What has been presented to you is a situation that is clearly more sad than bad. We all regret the absence of young Aiden here today. And when I say we all, the community does. I mean, this is a tragedy that should not befall anybody. Mr. Thomas, as I've indicated to the court and the state knows, is 27 years old. He has no criminal history. He graduated Ben E. Mays High School in 2015. He currently works for United Natural Food Incorporated in their warehouse on Fulton Industrial Boulevard. In October of this year, he will have been continuously employed there for 2 years. Before that, I believe he worked at UPS for 5 years. And before that, at Imperial Dade Warehouse, which is a warehouse for cleaning products. So we have a young man that has continuously been employed and been a productive member of society and graduated high school and went to college and is still employed every single day. And he thinks about this tragedy every single day. And again, we have identified and said
that the mother of the child, Miss Kelly, is present. If you'd stand up for us, please. And you can hear from her, but I can proffer.
It entirely up to what you and she want to do.
Do you want to speak to the court? Yeah.
Hi, Ms. Kelly. I need you to be in front of a microphone so that Ms. Rivers can hear you. Thank you.
Would you tell us, the court?
If you could give me your first and last name.
Ashley Kelly.
Okay. Standard spelling, Kelly, Kelly.
Yes, sir.
Okay. And you were the mother of Aiden.
Yes.
Okay. Do you and Mr. Thomas have other kids?
Yes, just one.
Pardon me?
One
One?
Mhm.
Okay. A boy or a girl?
boy,
What's his name?
Dezal Thomas Jr.
And is he older? Was he older or younger than Aiden?
He's younger.
Okay. How old is he now?
He's 2.
He's 2. Okay. So he wasn't around, because I heard Mr. Jordan say there were maybe 2 kids.
Yes, there was. I have an older son.
You have an older son.
Mhm.
Okay. Not with Mr. Thomas. Okay. Is he still in your household?
Yes.
Do you and Mr. Thomas still share a household?
No.
No. Okay. Got it. Does Denzal Jr. stay with you or with
Me.
with you?
Mhm.
How often does Mr. Thomas see Denzal Jr.?
Whenever he likes.
Okay. But does he take advantage of that opportunity and spend time with his son?
What you mean?
Does he see, I know you let him see his son whenever he likes. Does he actually do that?
Yes.
He spends lots of time with his son. Okay, that's what I was getting at. All right. But I've been doing all the talking. You wanted to say something and I'd like to hear from you.
He's a good dad. They love him.
This was a really sad accident. I'm sorry you had to go through that. What do you think I should do with Mr. Thomas?
He's a good dad. They love his dad. They love him.
Does he contribute financially? Is that helpful?
Yes.
And
Yes.
that was a nodded yes, just so we have the record.
Sure. Okay. I know this is very difficult, Ms. Kelly, and I'm sorry you're having to relive this, but it's a necessary part of this process so Mr. Thomas can move forward. Really appreciate you being here. I hope Mr. Thomas appreciates you being here as well. Was there anything else you wanted to add?
No.
Okay, thank you. Good luck with the next kid.
Thank you.
All right.
I also want to add one thing for the record. The weapon that was underneath the mattress was on the floor. The weapon was covered. The young child, as 3-year-old childs do, obtained it, and that's wherein this tragedy occurred. But that weapon was a Springfield XDS 9mm. That model had been recalled because of its unintended discharges, which would have been part of any kind of defense in the case. So, Judge, I am asking the court for he has been on bond and a productive member of society for 4 years now. So I'm asking for a sentence of, I want to say no more probation, but I know that's not a realistic, a 3-year term of continued probation. And that would end up being 7 years he's been enlarged in the community. And if, as we are going to request, and I'm requesting now, he is granted a first offender status, then he would also be eligible for a bid date. And when we're now 4 years down the road, and I would ask for a 1-year bid date, that means he would have been enlarged in the community and satisfactorily working
in being a member of the community without any problems for a period of 5 years. And I think that's pretty reasonable. So those are my two requests, and that's all I have to say.
Okay. How did you get involved with the case?
I was hired at the beginning.
Okay, I mean, initially there was a public defender, but at his first appearance or something, but you were retained, brought on by the family? Okay.
Yes.
And so you've been working with Mr. Thomas for many years. Nothing happened for many years, but you have been his counsel for many years.
That's correct.
Okay.
And he has always been very responsive to me. He's always expressed his regret. And he is always, and he said today, you know something, I want to come in to court. I want to put this behind me. I want to move forward with his life.
Okay.
And I respect that greatly.
Mr. Thomas, it's your turn. If there's anything you want to say, you don't have to say anything at all, but if there's something you think I should know before I decide what I'm going to do in terms of sentencing, now's the time. You've had many years to think about it.
I would just like to say, thank you for everybody's time, the prosecutor, your time, Bruce Harvey's time, Ashley Kelly time, everybody that's on the Zoom time. I mean, I regret that day so much. It's hard to think about. We miss Aiden so much. I'm a good person. All my kids love me.
How many kids do you have?
2.
2.
Yeah.
So I know about Denzal Jr. Heard about him. He's 2?
I have a baby girl.
A baby girl. Okay, and what does baby girl mean? How old is she?
She's 5.
5 years.
Mm-hmm.
Okay, so older than Denzal Jr.
Mm-hmm.
All right, does she stay with you?
No.
Is she in the Atlanta area?
Yes.
So you see her also?
Yes.
Okay.
All my nieces and nephews, they love me. I mean, every kid I come in contact with, they just bond to me. I mean,
why did you have a gun? I want to be clear, it was legal for you to have one. So it's not an accusation. It helps me understand the situation. Why did you have a gun in your household with 2 kids in it?
It was the area I was in. I was currently on the bus at the time. So I was like walking the MLK parts and all that stuff. So it basically was just for protection.
This was to get to the UPS place where you were working?
Yes.
Okay. And why did you keep it the way you kept it?
The reason I never keep my gun loaded with one in the head. The reason I assume it had one in the head because the day prior, well, I want to say 2 days prior, we was like having like family events and stuff. And I ended up going to a gun range with some friends and stuff and probably didn't load it right on the way back to the house or something. I'm not sure, but I didn't touch the gun for like 2 days into that night. And when I ended up taking it into the house, the gun was in my car and the glove department locked.
If you had a car, why were you taking the bus?
No, I ended up getting the car. I worked at UPS for 5 years.
Okay. And so you had the gun earlier for security because of the bus ride and the hours you work and both where you live and where UPS is.
Correct.
Later on, did well at work, bought your own car, and that's where the gun had been. You brought it back indoors the night before Aiden killed himself.
I had just bought my car 2 weeks prior before this incident happened.
Okay.
So, yes, but to answer your question, yes, I did bring it back in the house.
Okay. But my question was, why did you put it under an air mattress?
Because of that night, Ashley Kelly wasn't originally supposed to come to my house. So in that night, for some reason, I was just tired. I just felt so tired, but I just wanted to go to sleep. And when I went in my room, I just laid down on the bed. I just dropped everything and laid down on the bed and cut off the lights. And like, I want to say.
And at that time in your house, there were no kids?
No, there were no kids.
You could put your stuff wherever?
There was no kids. And like, I want to say like 30 minutes to an hour later, I get a call. It was Ashley with Aiden on the phone, and he said he wanted to see me. So I told her to come over.
Okay. And you had just dumped your stuff on the ground, and that's why the firearm wasn't in a safe place.
Yes.
Okay. First offender, Mr. Thomas, is something for which you qualify. It is an opportunity that we afford someone who has no criminal history like you. And it is primarily a benefit. It means that if you successfully complete your sentence, then the memories of this never go away, to be clear. But on paper, this goes away. If you leave here today, it is not a conviction. You'll be what we call someone on a first offender sentence. And if you successfully complete that sentence without a revocation, getting in trouble again, et cetera, then you can have this removed from your record. Again, no one forgets about what happened, but in the future, an employer, if they run your criminal history, it doesn't show up because it's not a conviction. That's a benefit. The risk is that if you get mixed up in something, and I'll give you a real specific example. If you get arrested and there is a gun on you, near you, in your car, in your bag, in your house, because you can't have a gun while you're under a first offender sentence, that will come back to me and I will send you to prison because you had a gun around. You don't get to have a gun around as long as you're under this sentence. When you're done with your sentence, that is a personal choice for you about what is smart, not smart, safe, not safe. But that's the kind of thing. If you got arrested for having a gun, you get back in here, I would have the ability to take away your first offender status and resentence you because you've already pled guilty. And given what you're pleading to, that resentencing could be up to 20 years, 10 for the involuntary manslaughter and 10 for the cruelty to children. I am not saying that's what I would do necessarily, but you need to know that there is a real steep downside to first offender if you aren't so sure about how you're going to live your life going forward. I'm not preaching to you how you're going to lead your life. You know that though. And if you think, I might be mixing it up some, then you should not take first offender because it will be a bad outcome for you if we're together again. It doesn't matter what Mr. Harvey has to say. If you are around guns, there will be consequences you don't like. So I need to make sure you understand the downside of first offender because the upside, everyone gets it. Yeah, I want that lawyer. That's what I want you to ask for that. But there's that risk too. Do you feel like you understand the benefit as well as the risk of first offender?
Yes, Your Honor.
Do you want to be sentenced as a first offender?
Yes, Your Honor.
Okay. Tell me about your current job. Where is it?
It's located on Fulton Industrial.
What hours do you work?
I work from 9 a.m. till the job is done. Basically, there is no end time,
Oh.
so I could be working all day basically.
And which of the warehouses you had UPS, you had Imperial, something? What is it that was cleaning supplies? This one is produce.
Yes, food.
Okay. Do you get paid overtime? If you work more than 8 hours because the job's not done, do you get overtime?
Yes, yeah. I mean, no, not by the day. You got to get over 40. The job is kind of dysfunctional right now, but we're in the process of getting a union.
Oh, good luck with that. You may need a different lawyer.
Yeah.
So 9 a.m. till whenever, what days during the week?
I'm off Tuesday, Wednesday. So Thursday through.
Okay. Your weekend is Tuesday, Wednesday.
Mm-hmm. Correct.
All right. And you've been in this job, it sounds like in 4 months, it'll be 2 years.
Yes, sir.
Do you plan on staying on it despite the dysfunctionality and these union threats?
I do.
Okay.
It pays good.
Okay. What does it pay an hour?
Like 21, 22.
Do you get a paycheck? So it's going into like a direct deposit into a bank account?
Mm-hmm.
Like it's that stable. You don't even see the money. It goes straight into an account. All right. You go say yes.
Yes, Your Honor.
Yes is fine. You don't need the other stuff. That's for Mr. Harvey. Well, Mr. Thomas, I find there's a factual basis for your plea. We all now know, and Ms. Kelly knows better than anyone, but Mr. Jordan's recitation of the facts was very helpful. I think we all understand what happened here. You were careless, not intentionally so. This is not a case where I'm looking at someone that I'm kind of afraid of because when you get angry, you pull out a gun. We don't even need to be angry. Someone is wearing the wrong color shoes. You know what? You were in my neighborhood with the wrong color shoes. I'm gonna pull out my gun. That's not this case at all. You've helped me understand why you had a gun, why it was not in a safe place far out of Aiden's reach. That doesn't excuse what happened, but it helps explain what happened. So I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about anything Mr. Jordan, Mr. Harvey, or that I have said?
No, Your Honor.
It's okay if you do. I just want to make sure you're straight right now. Yes?
Yes.
Okay. I also find that your plea is voluntary. That means that while this is not a happy moment for you, no one's forcing you to be up here entering your guilty plea. Is that correct?
Yes.
All right. Mr. Thomas, there is nothing that I could do in terms of handing down a sentence that would be worse than you holding your dying son in your arms. Just hearing Mr. Jordan talk about how the other kid saw you, I guess it was your nephew, saw you running out holding Aiden. You knew he was, if he wasn't dead then, I mean, based on what you saw, you were holding your son as he died. I could sentence you to 20 years and that memory and that pain doesn't go away. And that wouldn't be the right sentence because I believe Ms. Kelly and I believe you that this was the absolute worst tragedy you could have. And there's nothing you can do to fix it. I hope every day, or at least every time you think of Aiden, you wish it could have played out a different way. And it can't. And you have the memory that no parent should have of holding their kid as there's that last breath, and it's worse. There's blood everywhere, brain material. That's your punishment for being reckless, is having to carry that with you. And I feel for you because 30 years from now, that's still there, and you'd be done with any sentence I could give you. And I appreciate that Ms. Kelly is here today. That is proof positive, the best proof that you were a good dad for Aiden, you remain a good father for Denzal, for your daughter, and it may be that you spend time with Ms. Kelly's other kids. You sound like a well-meaning, hardworking young man. You just have this burden that most of us don't, and I feel for you in that way, and that's your main punishment. I'm sentencing you pursuant to the Probation Options Management Act. What that means, Mr. Thomas, is that while you are on probation, if you have a small probation violation, I have a sneaking suspicion you'll have none. But if it's what we call a technical violation, maybe you miss a meeting, or I'm making this up, I'm saying nothing about your lifestyle, but let's just say hypothetically you tested positive for marijuana once. You and probation work through that. You don't have to come see me. If you get arrested for anything, you're around guns, that comes back to me. Probation will play a role in that, but I will be the decision maker as to what happens as a result of that future conduct. So, Mr. Thomas, I'm going to sentence you as follows. I need to check one thing again because I forgot the number.
Is it the amount of days in custody, Your Honor?
It is, but I found it again. I thought it was less than 1 month. It is. So, Mr. Thomas, I'm going to sentence you. So count one has been null prost, correct?
Correct.
On count two, I am sentencing you to 5 years to serve 25 days with the balance on probation. You'll get credit for the 25 days you've already served. The balance will be probated. Count three is the same sentence, so it'll run concurrently. Count four, I agree, merges into count two. So you have two felony sentences. Well, it's one sentence. It's 5 years to serve 25 days with the balance probated. You, Mr. Thomas, will need to spend 10 two-day windows. I'm going to call them weekends, but they are Tuesday, Wednesday. 10 weekends in custody. You will need to turn yourself in Monday by 6 p.m. to the county jail. And we're going to fix the start date in a minute. Be 10 consecutive Tuesday, Wednesdays that you'll be in custody. So you'll turn yourself in Monday by 6 p.m. You'll get out Wednesday by 6 p.m. We'll figure out what the start date is in a moment. That's a condition of your probation. I will set a behavioral incentive date of 3 years, and that will be August 10th of 2027. So if you have done everything expected of you on probation, which after you do those 10 weekends is just stay out of trouble, there have been no issues, then probation can petition to have your case shut down, which they will do if you're doing fine, because there are plenty of people on probation who are a complete pain. And I don't get the sense that's going to be you. If it ends up being you, it just means after 3 years, I tell you, you got 2 more years of probation. But if you want to shrink that, you can shrink it. Let me talk about start dates for those 10 weekends. Next month, well, next Monday is soon. That's the 12th. My thought would be we start on the 19th. So at 6 p.m., you go to the county jail on Monday the 19th. And you get out Wednesday at 6 p.m. and you just do that for 10 consecutive 2-day periods. But I don't know if you need to run that by your employer. You told me Tuesday, Wednesdays were safe days for you, which is why I'm structuring it that way. Do you need to talk about that with Mr. Harvey, or you're pretty sure you're a valued employee there, you can make this work?
I'm a valued employee. I could probably make it work.
Okay. Then should I have your sentence indicate that you start your 2-day jail periods on Monday, the 19th of August? So that's not next Monday. It's the Monday after.
Yes.
Does that work?
Yes.
Okay. All right. Mr. Jordan, do you have anything else you want to add in connection with Mr. Thomas's case?
Nothing further on behalf of the state, Your Honor.
All right. Mr. Harvey, do you want to discuss this outcome with Mr. Thomas? Are you good to go? Anything you want to add?
If he's got no questions for me, I'm good. Any questions I can answer for him.
Okay. Is there anything you want to talk about with Mr. Harvey before we make this final?
No, Your Honor.
Okay. There is one more conversation you need to have. Officer Brown is on this call. She is with probation. She's not going to be your probation officer, but she needs to give you probation reporting instructions. It's based on your address. Do you live in Fulton County?
No.
What county do you live in?
Clayton.
Okay, so you're going to report to Clayton. She's going to give you the location and the date when you need to report that first time. Do not miss that date. It needs to not be a Tuesday or Wednesday because you're not free then, but it's going to be in the next few weeks. That's when you get your officer assigned to you. They get all your data and your probation is up and running. If you miss it, they send me a warrant and I'm saying, man, I totally misunderstood this guy. He seemed like he was squared away and he's not. All of these things we've been talking about, your reporting date, these weekends in jail that you have, if something comes up, your kid is sick, you need to be at Hugh Spalding with him. Let Mr. Harvey know. He will reach out to my office and we can work around it. If you need to miss one of those 2-day periods, I'll just move it to the back end. But I get a report from probation. And if they say, hey, Mr. Thomas, he did the first 2 and then he stopped showing up, fine, I'll sign a warrant and I'll just lump them all together and probably add some to them and say, well, why don't you spend a month in the jail instead? So don't be loosey-goosey with him. If there's a reason you know you're going to miss one because of a family emergency, let your lawyer know and we'll handle it. But what doesn't work is for you to just skip it and later on say, oh, you know what, my car broke down. That's too late. Okay?
Okay.
All right. Officer Brown?
Yes, can I have
Mr. Thomas, I am sorry for what you and Ms. Kelly went through. Like I said, that should happen to no parent. I got kids. I cannot imagine what that would be like. I'm not sure I would have made it out. And there was a loaded gun right there. I don't know what I would do after something like that happened. be careful in the future. You've got other kids and they depend on you, okay?
Yes.
All right, be safe.
Okay, thank you, Your Honor.
Mr. Harvey, thank you for working on this case. And Mr. Jordan, you in particular, thank you for taking the usual, reasonable, thoughtful approach you take to these.
Thank you, Your Honor.
Thanks, Judge. May I be excused?
Yes.
I am very interested to know if you share my feelings, and obviously Judge McBurney's, that this was an epic F-up on the part of the young father coming up in a rough area, just trying to make it, support his family. Or if you see it differently, tell me in the comments. I like to hear your opinions. Sometimes you sway mine, and sometimes you enlighten me, and sometimes you're just batshit crazy, but that's not very often. I feel in this case, 99% of the time, he would have woken up, maybe said, shit, I shouldn't have left that there with the kids here. Maybe remembered not to do it again, maybe not, and gone on with his life. He unfortunately was in that tiny little percentage where tragedy happens and they will all pay for his mistake for the rest of their lives with the loss of a sweet, innocent little boy. But that's life. Until next time.